Welcome, everyone. This is one of the final two sessions of the Florida Bar Crash Course for July 2023. And we've come a long way to get to this point, right? We started with contracts, we went all the way to ethics. And now we have to reel it all in and remind ourselves of what's important and what can we do in the final few days to really lock in a passing score. Remember, the Florida Bar is two parts. Part A is essays, part B is multiple choice. We're going to spend the last workshop doing essays, and we're going to go on the complete review, go over all the questionnaires, and I'm going to make sure that everyone in this room feels very, very sharp about writing essays. Today, the purpose is to feel really, really sharp about multiple choice. So, Ariane, if you wouldn't mind, could you share the screen right now to our Florida multiple choice interactive Q bank? Oh, this is cool. Okay, so just to give everyone out there an overview, if you click up, if you scroll up on the left-hand side of the screen, all the way to the left, like, yeah, there, you could just see the different subjects that we have. There's 8 subjects, 50 questions each, that's 400 questions. And then there's a mixed question review, that's 433. I really encourage everyone to go through all 433 and memorize the questions and know them cold. So let's just click on a few to show people what they're like. Why don't you click on Will's? Let's see if we can do some Will's questions. Yeah, retake the quiz. Why don't you?
Yeah, I just did it today. Yeah, so I'm gonna retake.
You only got 90%? I'm just kidding.
Yeah.
Okay.
Because
So
I
let's look
wasn't
at-
that focused.
I'm just messing with you, Aaron. So look at this one. Sean executed a valid will in Florida, which provided for three friends, Brian, David, and Beyonce, to receive equal shares of his estate. Sean later executed a codicil that revoked the provision for Brian, leaving the entire estate to David and Beyonce in equal shares. However, Sean then destroyed the codicil. What will be the distribution of Sean's estate upon his death? So here we learn a few concepts, the concept of a will and the concept of a codicil. So if you destroy a codicil, will that destroy the will or just the codicil?
Just the codicil.
Just the codicil. So the terms of the will remain, and the will distributed the shares evenly to David and Beyonce, right?
Yeah, the three of them, right? The first
Yeah, I would say scroll up a little bit so I can just see. The original will left it to Brian, David, and Beyonce in equal shares. So in this situation, we've only revoked the codicil. The terms of the will prevail. I think the answer should be D, that all 3 of them will get 1/3 of the estate per the terms of the will. Let's see it. Exactly. And you see we have explanations. Brian will receive 1/3 of the estate. David and Beyonce will each reserve 1/3 of the estate. The codicil was revoked. So remember, there has to be intent and physical act. If you intend to revoke the will, but you rip up the codicil, there'll be no effect. And we'll see that in a later question. Let's try one more Will's question, and then we'll move on to another subject. And then I'll show you all why we're here today. I guess we'll do this one even though it's long. Jeff had a son, Mark, and a daughter, Lucy, from his first marriage. When he married Karen in 2015, he updated his will. In the will made in 2017, he left half of his estate to my wife, Karen Turner, and divided the remaining half equally between his son and daughter. In 2019, Jeff and Karen decided to part ways and got divorced. So Karen is now taken out of the will. However, amidst the life changes, Jeff never got around to revising his will. Jeff passed away this year, leaving behind Karen, Mark, Lucy, and his mother, Mary Harrison. How should Jeff's estate be distributed according to the following scenarios? So now we need to understand that when you get divorced, you are effectively taking that person out of the will. So I like what B is saying, where as the will is nullified only in regard to Karen due to divorce, Mark and Lucy should inherit their estate equally. We like that one, Ariane? Yeah, let's try that one. It only nullified her piece. See, so these questions, they're not super difficult, they're not super easy, but you should go through them. And my favorite word, green light this, right? We're going to green light these and get all 400 of them correct. Now, if you scroll down a little bit, Ariane, you could do this for every single subject. Why don't we look at the mixed question review? This is a 33 question quiz I made that is totally new questions from the 400, and you could just take a peek in here. In Florida, according to the law on filing formal charges, which of the following options correctly describes the outcome if defendants in custody remain uncharged within the specified time frame? I love this question. Whoever wrote this question really cares about his students passing or their students passing, because it's important to know the rule about you have 30 days from arrest for them to bring charges, and if they don't, they have to release you on the 33rd day unless they can show good cause, and then they'd have another week extension. So that seems to be the answer to letter A. The defendants must be released on their own recognizance on the 33rd day, because 30 days and then 3 days to be released, unless the state files formal charges by that date or on the 40th day of good cause as shown by the state. So I'm going to choose answer A here. So everyone out there should feel really comfortable. If you want to access these questions, the link is in the bio. These are 400 questions written by me, and I think my secure transactions and commercial paper questions are my best ones. I have an MBA, I teach for the Series 766, and I wrote those questions to really help students master this material. But today I want to do what I think is going to be the most valuable exercise that could ever be done. And everyone knows how to do this, but no one's ever had the opportunity to do it like we're going to do it, which is go through the official FBBE questions. The Florida Board of Bar Examiners has released 69 questions and answers that you should know cold as ice. And as Joelle just told everyone, a lot of the multiple choice questions on test day are almost verbatim. So in that sense, if you don't know the 69 questions cold, you're really doing yourself a disservice. How could you learn the 69 questions when all they gave you is the questions and the answers and no explanations? There's really no way. Until now, we have added all those questions and the answers and the explanations to this platform, and we're going to do them now together. And I want everyone to know this. When you take the test on Tuesday, you're going to write your 3 essays and you're going to crush them. And then you're going to go have lunch, and you're not going to have lunch with your friends because it's a business trip, as Joelle said. And when you go to have lunch, you're going to have your headphones in. Bring your phone and your headphones into the test center, bring them in the cubby room and stash them. And then right after the exam, grab your phone, grab your headphones, make sure your phone's nice and charged, and then go to wherever you're going to have lunch. Pull out this software, ibisprep.thinkific.com, and pull up these 69 FBE questions. And during that lunch break, go over them until all you see is 69 straight green lights. If you do that, you will have tremendous success on the Florida Bar multiple choice section. This is the ultimate way to crush this section. There is no other thing to do. Everything that we've done has been in preparation for this, because now we have to do what's most important. What's most important is memorizing these 69 questions cold. So Luis is saying you can't see the platform. I think you have to press view area and screen. Everyone else can see it, right? You can see the questions. Yes, Amy can see it. So Luis, let us know if you can see the platform. I think you have to press view area and screen or anything like that. If someone could private message Luis and help him out, that'd be amazing. All right, so without further ado, let's jump into the official questions. They haven't been changed one bit. These are the questions they released. They're disclosed and available to the public. And what we've done is written our own explanations so that people could get a little deeper of understanding. So feel free to write in the chat, feel free to talk. Let's understand these. After the close of the pleadings, both plaintiff and defendant duly made motions for summary judgment. Which of the following statements is correct? Summary judgment can be entered only after discovery has been completed. Motion for summary judgment is the proper motion on the ground that plaintiff's complaint fails to state a cause of action. Since both parties have filed summary judgment motion that assert there are no genuine issues of material fact, summary judgment for plaintiff or defendant will be granted. If plaintiff's proof submitted in support of his motion for summary judgment are not contradicted, and if plaintiff's proof show that no genuine issue of material fact exists, summary judgment will be granted, even if defendant's answer denied plaintiff's complaint. We're getting a lot of D's in the room, and D is correct. What I will say is, please, no one respond until I ask for the answer choice, because Scarlett, we literally just did these questions before class. Like, I'm sure you know them pretty well. But everyone else, please don't answer until I ask for answers. But yes, D is correct. If the plaintiff's proof submitted in support of the motion for summary judgment are not contradicted, and if a plaintiff's proof show that no genuine issue of material fact exists, summary judgment will be granted, even if defendant's answer denied plaintiff's complaint. Summary judgment is a procedural device used in civil litigation to promptly and efficiently dispose of a case without a trial. It is used when there's no dispute as to material facts of the case and the party making the motion is entitled to judgment as a matter of law. In this case, the plaintiff provides evidence that is not contradicted, and if it shows that there's no genuine dispute of material fact, then the judge can rule in the plaintiff's favor, granting summary judgment, even if the defendant's answer denied the plaintiff's allegation. The key here is that the defendant has to provide more than just a denial. They must offer evidence showing there's a genuine dispute of material fact to defeat the plaintiff's motion for summary judgment. Excellent job. Could we go to the next one? All right. Pete Smith is the active partner and Bill Jones is a silent partner in a general partnership known as Pete Smith Plumbing. After 6 years of being uninvolved in the management of the business of the partnership business, Bill purchases 100 toilets for the business. Pete is incensed because it will probably take years to use up the inventory of so many toilets and seeks your advice. The best advice is Bill can bind the partnership by his act. Silent partners are investors only and cannot bind the partnership. Unless his name is in the partnership name, third persons are on notice that he is authorized to contract for the partnership. Bill, as a silent partner, is not authorized to purchase, and therefore the sale may be set aside. The answer is A, yes. Good job, Natalie. By the way, your brother texted me and said to call on you a lot in class. I don't know if that's weird or not, but your family loves you. Bill could bind the partnership.
Andrew?
Yeah.
Sorry, we were asking in the chat, but could we do a full screen on the questions? There's like there's a button on the top right there above the scroll bar.
Am I supposed to press or Ariane?
No, she's got it now. Thank you, Ariane.
Okay.
Is this one?
Yeah.
Okay, perfect.
So, I'm
Sorry about that.
put-
I can't see the chat. That's why I didn't do anything.
No, thank you, Ariane. You're amazing. Okay, let's look at the answer to A. Bill can bind the partnership by his act. So can you scroll down to the explanation? And again, we're only human. This was created by me and my little cousin. So if there's any errors, we'll fix them tonight, but hopefully there should be none. Bill can bind the partnership by his act. In a general partnership, each partner is an agent of the partnership for the purpose of its business. This means that an act of a partner, including the execution of contract, can bind the partnership if the act was done in the ordinary course of business or the partnership with the authority of the other partners. Even if Bill is a silent partner not typically involved in the management, he still legally has the authority to bind the partnership in business transactions unless there was an agreement that specifically restricted Bill from this type of activity. All right, let's try the next one. Defendant was seen leaving neighbor's yard with neighbor's new $10 garden hose. Neighbor called the police, who charged defendant with second-degree misdemeanor of petite theft by issuing a notice to appear in the county courthouse 1 week later. Must appoint defendant a lawyer, must appoint defendant lawyer if the state subsequently charged defendant by information, need not appoint defendant lawyer if the judge states in writing that defendant will not go to jail for more than 6 months if convicted, need not appoint defendant a lawyer if the judge states in writing that defendant will not go to jail at all if convicted. People are between C and D. I believe it's D. You believe D, Ariane? Yeah, I believe D. Let's check D. There's some D's on it. D, need not appoint defendant if a lawyer if the judge states in writing that the defendant will not go to jail at all if convicted. An indigent defendant has a right to appointed counsel in any case where they face potential imprisonment, no matter how brief. However, if the judge can guarantee in writing that the defendant will not face any jail time if convicted, then there is no constitutional requirement to appoint counsel. So it doesn't matter if it's 6 months, it's any jail time at all. Which statement best describes the profit-sharing relationship of a general partnership where the partners have agreed only on voting percentage and the voting shares are unequal? Partners share in proportion to their contributions to the capital and assets of the partnership. Partners share in proportion to their voting percentage. Partners share equally. Partners cannot share until they unanimously agree upon distribution. Yeah, everyone's picking C. I like C. If it's silent, partners are going to share equally. Let's see it. Let's see. The answer is C. Partners share equally under the Uniform Partnership Act, which serves as a model for many states' partnership laws. So we would use RUPA. Profits and losses of a general partnership are shared equally among the partners unless there's an agreement specifying a different arrangement. This is the case even if the partners have contributed different amounts of capital or of unequal voting shares. Hey, what's up, Isadora? Just joining us. I'm letting you know we're doing the official FBBE questions, and this is the first time in the history of the world that anyone has ever read explanations or done these questions interactively. Shout out to my little cousin Jacob and to Ariane, who's doing a great job. So Billy was charged with grand theft. The trial began on Thursday afternoon. The jury was impaneled, sworn and recessed for the day. Since Friday was the 4th of July, the judge asked the jurors to return on Monday. The trial began on Monday morning at 8:30. By late evening, the judge had instructed the jury. Due to the lateness of the hour, the jurors were sequestered for the evening to allow them to get an early start the next morning. The jurors returned Tuesday morning and were unable to reach a verdict. Unable to reach a verdict, the trial judge allowed the jurors to go home that evening. So what was the error here? The fact that the jurors did not begin to consider evidence until several days after they were impaneled, the fact that the jury was allowed to go home after being sworn, the fact that the jury took several days to return a verdict, the fact that the jury was allowed to go home after they began deliberations. Everyone's picking D. The answer is D. And it seems like some of the questions have been a tiny bit cut off, and that responsibility falls squarely on my shoulders, not Jacob or the FBBE. That's all my fault, and I'll fix it tonight. The fact that the jury was allowed to go home after they began deliberations. This is likely the strongest point of appeal because once a jury begins deliberations, they're typically sequestered until they reach a verdict. This is to ensure that they're not influenced by outside sources or information during the deliberation process. Allowing the jury to go home after they began deliberations may have exposed them to external influences which could potentially impact their decision, thus raising concerns about the fairness and integrity of the trial. Good job, everyone. Kendall and Thornton agree to form a partnership, but both agree that only Kendall will manage the business and make all business decisions and execute all contracts with third parties. After that time, Thornton then enters into a long-term service contract for the partnership with Clark, who does not know of this internal agreement. The contract of Thornton with Clark is enforceable as the partners' agreement cannot withhold statutory authority of a general partner to bind the partnership. Enforceable as Clark has no knowledge of Thornton's lack of authority. Unenforceable as Thornton is unauthorized to execute the contract by partner agreement. Unenforceable as Clark had an obligation to confirm Thornton's authority prior to entering into a service contract with the partnership. Yeah, B's. I like B. Right, it's going to be a partnership by estoppel. Or not necessarily, but a parent authority. I'm sorry, I mean to say partnership, but I thought stop will be a parent authority. Enforceable as Clark has no knowledge of Thornton's lack of authority. The law recognizes the principle of parent authority in partnerships. This means that if a partner like Thornton appears to be a third party like Clark to have authority to enter into a contract on behalf of the partnership, the contract can be binding on the partnership. This is particularly true if Clark had no knowledge of any agreement between the partners limiting Thornton's authority. So this is going to be a parent authority. Even though you didn't have knowledge of the lack of authority, it seemed like they had authority. That comes up all the time on business entities questions. If you see a partnership question, you're not sure if they can bind them or not, most likely they can bind them under a theory of parent authority. The state of Florida is prosecuting a former police officer for extortion of money from prostitutes. One of those state witnesses is Sally. Sally has an adult conviction for vehicular homicide. She was charged with driving a car in a reckless manner, resulting in the death of her sister, a passenger in the car. Sally pleaded nolo contendere, was adjudicated guilty, and received a suspended sentence, although she could have received a sentence of state imprisonment up to 5 years. At trial, evidence of this conviction is admissible to impeach Sally because vehicular homicide carries a maximum penalty in excess of 1 year. Inadmissible to impeach Sally because she never admitted to her guilt since she entered a plea of nolo contendere. Inadmissible to impeach Sally because she received a suspended sentence. Inadmissible to impeach Sally because she is only a witness and not the criminal defendant. Yeah, A's, right? Admissible to impeach Sally because vehicular homicide carries a maximum penalty in excess of 1 year. In Florida, a witness's credibility can be impeached by evidence of a criminal conviction if the crime was punishable by death or by imprisonment for more than 1 year, or involved dishonesty or false statement, regardless of the punishment. Sally's conviction for vehicular homicide, which could result in state imprisonment up to 5 years, meets this criterion. The fact that she entered a plea of nolo contendere, no contest, does not change the fact that she was convicted, nor does the fact that she received a suspended sentence. The fact that she was a witness and not a defendant does not protect her from impeachment by evidence of her conviction. If anyone has any questions at all, you can stop me. A defendant charged with first-degree murder shall be furnished with a list containing names and addresses of all prospective jurors. I don't want anyone to answer this question. Please don't. Upon court order, upon request, let's see how well people can follow the rules. Please, no one answer this question. Upon court order, upon request and showing of good cause under no circumstances. Hey, Barbara, are you with us?
Yep, I'm here.
What do you think the answer is to this one?
I mean, I know the answer now. I think it's still crazy, but I know it.
What is it?
Upon request.
Let's see it. Let's run it. Still the answer. Still crazy, but still the answer. Generally, in many jurisdictions, the defense and the prosecution in criminal trial have the right to access a list of potential jurors, also known as the veneer or jury pool, upon request. This is part of the broader right to a fair trial and enables the parties to prepare for a voir dire, the process of questioning potential jurors to determine if they are suitable for jury service in a particular case. You know, who cares what you knew? It's what you're being tested on. So it doesn't matter if it's crazy, just look for the correct answers based on repetition, familiarity. Cooper is suing March for money damages. Because he believes portions of March's deposition are highly favorable to his case, Cooper's attorney intends to read parts of the deposition at trial instead of calling March to the stand. March objects to Cooper's use of the deposition at trial. What is the court's likely ruling? Cooper may use the deposition at trial, but if requested, he must read all parts that in fairness ought to be considered with the part introduced. Cooper may use the deposition at trial, but only to contradict or impeach March's prior inconsistent statements or pleadings. Cooper may not use the deposition at trial, as March is able to testify and no exceptional circumstances exist. Cooper may not use the deposition at trial, as this would make March his witness and immune to impeachment. Email answer. Yeah, A's, definitely A's, right? See what's going on. Cooper may use the deposition at trial, but if requested, he must read all parts that in fairness ought to be considered with the part introduced. Florida allows the use of depositions in court. If one party presents part of a deposition, the other party may request that additional relevant parts be read into the record to ensure a complete and fair understanding of testimony. Further, an adverse party may require the introduction of any other part of a witness's deposition that ought to be considered in connection with the part introduced. This is to avoid the possibility of presenting the deposition testimony out of context. Jan sues the Chicago Times for defamation in Florida Circuit Court. At trial, Jan wishes to offer into evidence a copy of the edition of the Times containing the allegedly libelous article. Before the newspaper may be admitted, Jan must A, call as a witness and employee of the Times to testify that the proffered newspaper was in fact published by the Times. B, have a certification affixed to the newspaper signed by an employee of the Times attesting to its authenticity. C, establish that the newspaper has been properly certified under the law of the jurisdiction where the newspaper is published. And D, do nothing because the newspaper is self-authenticating. The answer is definitely D. And A, Andrew also needs to fix a small thing. B, do nothing because the newspaper is self-authenticating. In Florida, certain items are considered self-authenticating, meaning they require no extrinsic evidence of authenticity in order to be admitted to evidence. This includes newspapers and periodicals. The rule states that they are presumed to be what they purport to be and can be admitted without additional evidence proving they are genuine. Look for that. Newspapers are self-authenticating. Defendant was arrested on February 1st and released 1 month later on March 1st after being charged with a felony. On December 1st of the same year as his arrest, he filed a motion to discharge since no trial or other action had occurred to that point. The court held a hearing 3 days after the motion was filed. Defendant should be discharged because more than 175 days passed between arrest and the filing of the motion to discharge. Discharged because more than 175 days passed between his release from jail and the filing of the motion to discharge. Brought to trial within 90 days of the filing of the motion to discharge. Brought to trial within 10 days of the hearing on the motion to discharge. The answer is D. As in, does anyone have anything else for me to drink? I'm thirsty and out of Coke. The defendant should be brought to trial within 10 days of the hearing on the motion to discharge. In the state of Florida, this rule, 3.191, stipulates rules related to speedy trials. According to these rules, the defendant charged with a felony should be brought to trial within 175 days of arrest. If no trials occur within this time period, the defendant can file a notice of expiration of speedy trial time or motion to discharge. If such a notice or If such a notice or motion is filed and the hearing is subsequently held on this motion, the prosecution has 10 days from the day of the hearing to bring the defendant to trial. Applying these rules to the given scenario, the defendant filed a motion to discharge on December 1st, since no trial or other action occurred up to that point. The court held a hearing 3 days after the motion was filed. Therefore, under Florida's rules, the prosecution has 10 days from the date of the hearing, not the day of the filing of the motion, to bring the defendant to trial. Bill, a single man, owned I don't know how I said it. I was like, a single man. I can relate. How nice it must be. Bill, a single man, owned pasture land in Deerwood, Florida, which he leased to a tenant. He also owned a condominium in Florida, which he held for investment. In his will, he divides the pasture land to his son, Tommy, and the condominium to his daughter, Julie. All other assets would pass equally to Tommy and Julie. Kathy gets the condominium regardless of the prenuptial agreement. Tommy takes the pasture land and Tommy and Julie split the rest of the estate. Due to Kathy's prenuptial agreement, Tommy receives the pasture land, Julie gets the condominium, and Tommy and Julie split the rest of the estate. Kathy gets the condominium, but because Bill had originally indicated his intent to divide equally to his children, Tommy and Julie will split the remaining estate. Regardless of the prenuptial agreement, Kathy is a preterminated spouse. Since Bill leaves surviving lineal descendants who are not Kathy's, Kathy receives 50% of the estate, Tommy gets the pasture land, and Tommy and Julie split the residue of the estate. Issa's the only one with any, okay, Issa and Scarlett. I'm rocking with A2. A is in Andrew. A is correct. Holy moly. Kathy gets the condominium regardless of the prenuptial agreement. Tommy takes the pasture land and Tommy and Julie split the rest of the estate. In Florida, real property owned as a tenancy by entirety passes automatically to the surviving spouse upon the death of the other spouse. This type of ownership is a form of joint ownership with the right of survivorship that is available only to married couples, tenancy by entirety. In this case, Bill conveyed the condominium to himself and Kathy as an estate by the entirety. This means that upon Bill's death, Kathy would become the sole owner of the condominium, regardless of the prenuptial agreement or the provision in Bill's will that divides the condominium to Julie. The prenuptial agreement is important in terms of Kathy's rights to other property in the estate, but would not affect the condominium because the condominium was conveyed to Kathy as Bill as tenants by the entirety after the prenuptial agreement was executed. Once the condominium was conveyed in this way, Kathy's right to the property upon Bill's death was vested, subject only to predeceasing Bill, which did not occur. Regarding the pasture land, this was devised to Tommy and Bill's will. Since there was no evidence of any changes regarding this property, it would pass to Tommy according to Bill's will. The rest of Bill's assets, which were not specifically devised in his will, would pass equally to Tommy and Julie as per the terms of the will. Kathy's prenuptial agreement means she waived her rights to claims on the rest of Bill's estate. Therefore, Tommy and Julie would split the rest of the estate equally. Anderson and Parker decide to form a corporation which will locate missing children. Which of the following would be a proper name for the corporation? Anderson, FBI Consultants Incorporated, Private Eye Partners, or Child Finder Company? Everyone's picking D. Let's go with D. Excellent. Child Finder Company. The name of a corporation must meet certain requirements under Florida law. Basically, all of them are bad, but D is good. This name accurately describes the name of the corporation's business and doesn't seem to violate any common name restrictions, making the best choice among the provided options. It provides a clear picture of the services the company provides. Ariane, can we take a quick break? Can you go to the Google Drive if you have it up, the Florida July 2023 crash course? I just remembered something that I want to show everyone. If you go to Florida 2023 crash course and you go to the materials folder, I have this thing called Anki, A-N-K-I. It allows me to make digital flashcards, but I realize that people don't like downloading things that are hard. So I turned all the flashcards into PDFs. So these were sent to me by a student. I think Hannah, she sent me these awesome outlines. I was like, you know what, let me make these into flashcards. So I turned her outlines into flashcards. And if you just open up, like, I don't know, do Civ Pro. If you just open up that one, it's super helpful. When can a party amend their pleading as a matter of course? You know, what is the requirement for a party whose mental conditions and it's a lot of really great things. And it's straight from these really great outlines, and I've turned them into flashcards. I'll show you for the MBE. I also did this with our questionnaires. I have tons and tons of flashcards, and they're all PDFs. So just make sure you're going back into the materials folder of the July 2023 course and just looking what's in there, because there might be new cool stuff until the very last minute. But halftime break is over. Let's get back into the questions. I just want to show everyone that I added that flashcard folder, flashcard PDFs. And the thing there is called paper clips. So if you do go to paperclips.app and you want to turn them into flashcards, you can drop PDFs in there and it'll turn it into Anki decks, and those Anki decks are flashcards, but you could also just use the PDFs. All right, let's go back into the questions. Thank you so much, Arian. That halftime show is brought to you by Ibis Prep. At trial during the plaintiff's case in chief, the plaintiff called as a witness the managing agent of the defendant corporation, who was then sworn in and testified. Defense counsel objected to the plaintiff's question either as leading or as impeaching the witness. In ruling on the objections, the trial court should sustain all the objections and require the plaintiff to pursue this type of interrogation only during the plaintiff's cross-examination of the witness during the defense case in chief. Sustain the leading question objections, but overrule the other objections because a party is not permitted to ask leading questions of his own witness at trial. Sustain the impeachment in questions, but overrule the other objections because a party is not permitted to impeach his own witness at trial. Overrule all the objections because the witness is adverse to the plaintiff and therefore may be interrogated by leading questions and subjected to impeachment. D's, yeah. D. Overrule all the objections because the witness is adverse to the plaintiff and therefore may be interrogated by leading questions and subject to impeachment. Leading questions and impeachment of one's own witness are generally discouraged or prohibited on the rules of evidence, as they can suggest the answer to the witness or undermine the witness' credibility, respectively. However, there are exceptions to these rules, particularly when the witness is considered adverse or hostile. An adverse or hostile witness is one who is aligned with the opposing party or has a motive to testify against the party calling the witness. In this case, the plaintiff is calling a managing agent of the defendant corporation. This witness would likely be considered adverse to the plaintiff given their affiliation with the defendant. Thus, the plaintiff should be allowed to use leading questions and potentially impeach the witness to effectively elicit testimony. Rainbow Corporation has outstanding 1,000 shares of voting common stock and 1,000 shares of non-voting preferred. The preferred has a liquidation preference equal to its par value of 100 per share plus a 3% non-cumulative dividend. Rainbow submits to its stockholders a proposal to authorize a new class of preferred stock with redemption rights that would come ahead of the old preferred stock. At a shareholders meeting, 700 common and 400 preferred vote in favor of the proposal. Which of the following statements is correct? The proposal is validly approved because overall majority of the outstanding shares did approve. Sorry, let me read that. The proposal is validly approved because overall a majority of the outstanding shares did approve. The proposal is invalidly approved because a majority of the preferred shareholders did not approve. The vote of preferred stockholders does not matter because it was non-voting stock. The proposal is invalidly approved because 2/3 vote of each class is required.
Can you scroll up for a second, please? Thank you.
Did anyone pick? Oh no. B's are coming in. Wait, yeah. B. The reason it's B is because it affects the preferred stock. I didn't think about it for a second. I was like, why did preferred get to vote? Because it's a new class. The proposal is invalidly approved because a majority of preferred shareholders did not approve. In this case, Rainbow Corporation proposed a new class of preferred stock with redemption rights superior to the existing preferred stock. This would impact the existing preferred stockholders' rights. See, that's why usually only common stock has a right to vote, but here it would affect their rights because it was a new class of preferred stock. Therefore, under Florida law, a majority of preferred shares would need to approve this change. With 1,000 preferred shares outstanding, only 400 voting in favor, this does not represent a majority of preferred shareholders. Therefore, the proposal has not been validly approved under Florida law, even though it received majority approval from common stockholders and overall. So usually you only need a majority from common stockholders on most things like, board of directors or stock split or merger or whatever. But this was directly affecting the preferred stockholders because it was creating a new class of preferred stock. So in this scenario, they did have to get their 50% or greater approval from preferred stockholders. This is a very tough question, just in general. All right, next one. And Barbara, welcome back. You made my heart drop when you left. I was like, why would you leave? This is such a valuable class. Bob Wilson borrowed $20,000 from Ted Lamar to open a hardware store. Ted's only interest in the business was the repayment of his 5-year unsecured loan. Bob was so grateful for the loan that he named his business Wilson and Lamar Hardware, and he purchased signs and advertising displaying his name. He also listed Bob Wilson and Ted Lamar's partners on his stationery. When Ted found out, he was flattered to the point that he voluntarily reduced Bob's interest rate from 9% to 8% per annum. A few weeks later, Pete Smith, who had assumed that both Wilson and Lamar were operating the hardware store and was not familiar with the true situation, sold goods to Wilson and Lamar Hardware. Pete Smith has been, please scroll down a little bit. Pete Smith has been unable to collect for the goods, and he seeks your advice. Your advice to Pete is only Bob Wilson is liable. Bob Wilson and Ted Lamar are jointly liable. Bob Wilson is liable for the entire amount, and Ted Lamar is only liable to the extent that debt cannot be collected from Bob Wilson. Only the de facto partnership arising from the relationship between Wilson and Lamar is liable. Yeah, B, they're jointly liable. You remember, usually you're going for that answer. They're jointly liable. They're, apparent authority, la-di-da-da. This is the partnership by estoppel one. Bob Wilson and Ted Lamar are liable jointly. The situation involves the legal concept known as partnership by estoppel. In general, partnership is a voluntary association of two or more persons to carry on a business for profit. However, under partnership by estoppel, even if there's no actual partnership, if a person represents themselves or allows themselves to be represented as a partner, they can be held liable as if they were a partner. In this case, even though Ted Lamar is only a creditor, not a partner in the traditional sense, he allowed Bob Wilson to represent him as a partner in the business. He did not object to the use of his name in the business name and accepted his designation as a partner on the business stationery. Furthermore, he lowered the interest rate on the loan when he found out about the representations, which could be interpreted as improving or endorsing the representations. Because Ted allowed these representations to go uncorrected, he could be held liable to Pete Smith, who provided goods to the business under the reasonable belief that both Wilson and Lamar were partners in the business. This principle is designed to protect those who reasonably rely on the representation of a partnership in their dealings with ostensible partners. It's important to note, my favorite thing, however, that partnership by estoppel only applies to third parties who rely on the partnership representation. It does not create an actual partnership between the ostensible partners. Beautiful. Just a beautiful statement. All right, we can continue. I really feel like all of your law school professors and deans should know about this service. Because if you were doing this your 3L year over and over and you had it memorized cold, it would have made this process a lot easier. And I would love to go to any law school and offer this platform. At the close of all the evidence in jury trial, thank you, Nicole. At the close of all the evidence, thank you, Natalie. Yeah, you guys warmed my heart. At the close of all the evidence in jury trial, defendant moves for directed verdict. After much argument, the court denies the motion. Subsequently, the jury returns a verdict for the plaintiff. The day after the jury returns its verdict, the court enters judgment for plaintiff. 1 week later, defendant moves to set aside the verdict and have judgment entered in accordance with his motion for directed verdict. In the motion, defendant raises argument that were not raised at trial. Plaintiff's counsel objects to the court even hearing the motion to set aside the verdict. Should the court consider the motion? Yes, because the defendant has raised new grounds. Yes, because the defendant has 10 days after the jury returns verdict within which to set aside the verdict. No, because the court denied the motion for directed verdict rather than reserving ruling. No, because the court entered final judgment for plaintiff before the motion to set aside the verdict was filed. Yeah, like B, 10 days after the jury. This is correct. Yes, because the defendant had 10 days after the jury returned its verdict with which to move to set aside the verdict. According to this rule of Florida civil procedure, if a motion for directed verdict is not granted, the court is deemed to have submitted the action to the jury subject to a later determination of legal questions raised by the motion. Not later than 10 days after entry of judgment, a party who has timely moved for directed verdict may serve a motion to set aside the verdict and any judgment entered thereon and to enter judgment in accordance with the motion for directed verdict. So, under Florida law, the defendant was in the rights to file a motion to set aside the verdict and have judgment entered in accordance with this motion for directed verdict within 10 days after the jury returned its verdict. The court should consider the motion regardless of whether the defendant arguments were previously raised at trial. Just a foreshadow, I'm going to write 3,000 brand new, never before seen MBE questions for February, and they're going to be so fire. And if you have the poor misfortune of having to take the MBE again, at least you're going to have access to that. In absence of a provision to the contrary in the Articles of Incorporation, the directors of a corporation elected for a specified term can be removed from office at a meeting of the shareholders, but only for cause and after an opportunity to be heard has been given to the directors, can be removed from office at a meeting of shareholders with or without cause, can be removed from office at a meeting of shareholders, but only for cause, can be removed from office prior to the expiration of their term only by decree of the circuit court and action by shareholders. Yeah, with or without cause. Why? Because who is it? the directors are at the pleasure of the shareholders, right? They can be removed with or without cause. Under most U.S. corporations, including Florida's, the default rule is that directors can be removed from office or shareholders with or without cause unless otherwise stated in the AOI or bylaws. The rationale behind this rule is to maintain shareholder control of the corporation. Shareholders are the owners of the corporation shall have the ultimate say in who is directing the affairs of the corporation. It's important to note that some jurisdictions require supermajority vote to remove a director without cause, while a simple majority is typically enough to remove a director for cause. But absent a provision, the articles of incorporation or bylaws specifying a different standard, the default rule applies. Should I put this video on YouTube? Or is that giving away too much juice for free? I'll let my people decide.
I hate to be the one,
all
but
right,
I'm
fine,
like,
fine.
an advantage. Huh.
All right, fine. All right, Amy, you say yes. I agree with you,
Athletes.
Amy. Because as King Solomon said, the world of the generous grows larger and larger. All right, Mary, a wealthy St.
Well-
Petersburg widow. It's all right. Mary, a wealthy St. Petersburg widow, executed her first and only will on May 15th, 1990, and died on August 18th, 1990. I was alive back then. Those were good old days. Her will provided that her estate be divided equally between her child Joan and the Salvation Army of Largo. How will Mary's estate actually be distributed? 100% to Joan, 100% to Joan if she files a timely petition requesting that the divides to the Salvation Army be avoided, 50% to Joan and 50% to the Salvation Army, 50% to Joan and the income for the remaining 50% to Joan for life, remainder to Salvation Army if Joan files a timely petition protesting the divides to the Salvation Army. Yeah, everyone's saying C. C sounds good. C, senor. Does anyone remember Speedy Gonzalez from my childhood? 50% to Joan and 50% to the Salvation Army. Based on the provided information, there's no reason to believe that Mary's will wouldn't be executed as she intended. According to the information provided, she has one child, Joan, and wants her estate to be divided equally between Joan and the Salvation Army of Largo. Unless there's some contestation of the will or it's found to be invalid in some way, Mary's estate will be distributed as she specified in her will. There's no suggestion in the information provided that Joan would or could file a petition to have the bequest of the Salvation Army avoided. It's also important to note that even if Joan were to contest the will, there's no guarantee that she would be successful. Thus, the distribution of Mary's estate should be as she specified in her will, 50% to Joan and 50% to the Salvation Army. If I do put it on YouTube, I'm going to put a Venmo link to Jacob because he's the true hero. Like, thank God for Generation Z. And I asked Jacob, I said, hey, blah, 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 can you get the work done? He said, absolutely. I'm like, man, it's so nice to have someone work so hard like I do. And he said, it's in my genes. And it made me think, he's my grandfather's first great grandson, and I'm my grandfather's youngest grandson. And him and I are kind of like the dream team. So big things coming. Regarding a deposition in civil court, which of the following is or are true? A deposition of a person against whom another person contemplates filing an action may be compelled by the party contemplating the action without leave of court before the action is filed. A deposition of the defendant in an action may be taken by the defendant without service of a subpoena on the defendant. A deposition may be taken even though all the testimony secured by it would be inadmissible at trial. You are going to see questions like this on the Florida Board on the multiple choice test. I promise you, and they suck. Fair warning. There's going to be 1 and 2, 1, 2, and 3. It's not like the Series 7. The Series 7 is littered with those types of questions. Florida multiple choice does have some, and they suck. Just, it is what it is. All right. Does anyone know the answer to this one? 2 only, 1 and 2 only. Let's see. 2 and 3 only, or 1, 2, and 3? Yeah, I like 2 and 3 only. Let's get it. 2 and 3 only, which would be C. I used to say C is in caterpillar and then C is in whatever. C is the correct answer. A deposition of a person against whom another person contemplates filing an action may be compelled by the party contemplating the action without leave of court before the action is filed. This statement is false. Generally, depositions cannot be taken before an action is officially filed. Under the federal rules of civil procedure and most state rules, a deposition requires an existing case. 2, a deposition of the defendant in an action may be taken by the plaintiff with or without service of subpoena defendant. This statement is true. If the defendant is a part of the lawsuit, they can be disposed with or without a subpoena. The plaintiff merely needs to give appropriate notice to the defendant or their attorney. And then 3, A depo may be taken even though all the testimonies occurred by it will be an inadmissible at trial. This statement is true. Depots are often used for discovery purposes to find out what a witness knows and to preserve that witness's testimony. The fact that the deposition testimony might be admissible at trial does not preclude taking the deposition. The purpose of a deposition can be to gather information and find leads to admissible evidence. What I should do, and everyone else does this, but I just hate doing it, is put like half the video on YouTube and then you have to like, for more, buy it. But I just like, as a consumer, hate when people do that. And I try not to do things I hate. I know, Natalie, that is what I should do, but
No,
like,
what you should do, Andrew, which a lot of IT professors do, is that they give the materials for free, but then they include a link so that you could donate, so that it's like instead of it being a free ride, it's like, okay,
yeah,
well, you know what I mean?
I know what you mean. I also know that I would get $0 donated, but it's all good. Assume for question 21 to 23 that following statutes and case holding are controlled. Don't worry about me, everyone. Let's pass this test. Don't worry about me and my business. We're going to be fine. We're going to be fine. Assume for question 21 to 23 that following statutes and case holdings are controlling law in Florida. This statute says where actions may be begun, actions shall be brought only in the county where the defendant resides, where the cause of action accrued, or where the property in litigation is located. This statute says actions against defendants residing in different counties. Actions against two or more defendants residing in different counties may be brought in any county in which the defendant resides. And then Gates v. Stucco Corp., the appellee contended that because the defendants were residing in Dade County at the time the cause of action accrued, it was immaterial where they resided at the time the suit was filed. The law does not support that contention. It is unimportant that the appellates reside in Dade County at the time of making of the lease or even at the time the cause of action accrued. The rights under the venue statute are determined on the basis of there being residents of Broward County at the time the suit was filed in Dade County. The statute as to venue applies as to the time of the filing of the suit and not as the time of accrual of the cause of action. Okay. Payne is a resident of Dade County, Florida, and was involved in a car accident in Broward County, Florida. Payne subsequently filed a complaint against Bryant and Davis in Dade County, alleging that they negligently operated their cars, resulting in permanent injuries to Payne. At the time of the accident, Bryant and Davis were both residents of Broward County. At the time the complaint was filed, Davis had moved and was living in Duval County, Florida. Bryant filed a motion to transfer the action to Broward County. What action should the court take? Grant the motion because the cause of action accrued in Broward County. Grant the motion but allow Payne to select either Broward County or Duval County. Deny the motion because Payne resides in Dade County. Deny the motion if Davis consents to venue in Dade County. So it could be kind of tough. Let's see. Two people are picking B. B's. One person's picking A. Anyone else have any thoughts on this one? I'm lost in the fact pattern. Are you pretty confident in B? Wait.
I think there was a rule, one of the civil procedure rules, the lawsuit can be brought forth where the defendant or defendants reside or domiciled.
Yeah, where one of the defendants resides.
Yeah, I like B. Let's try
So
B.
yeah, because the two defendants are in different.
Exactly. I got nervous on that one. All right. Grant the motion, but allow Payne to select either Broward County or Duval County. Based on the Florida statute 47021, an action against two or more defendants residing in different counties may be brought in any county in which any defendant resides. Nicely done, everyone. At the time of the lawsuit, Davis resided in Duval County and Bryan in Broward County. Therefore, since Payne is the plaintiff and the defendants live in different counties, he should have the option to choose either Broward County or Duval County as the location for the trial. Excellent. All right, we already know we're assuming. Let's scroll down. We're assuming the same stuff. So assume for this question only that Davis moved to Dade County after the accident and was residing in that county at the time the complaint was filed by Payne. What action should the court take in response to a motion to transfer to Broward County by Bryant? Grant the motion because the cause of action accrued in Broward County. Grant the motion, but only if Davis consents to transfer to Broward County. Deny the motion because Payne resides in Dade County. Deny the motion because Davis resides in Dade County. Can you scroll up to see where he originally filed?
I think the facts were in the previous question.
Yeah, same facts as they're in the previous question. That's all right. Just you can scroll down. Does anyone know what the answer is? I think it's gonna be D as in dog.
Right, because it's when at the time that it's filed where the defendant resides.
Exactly, it's where he's filed, and he's right. Deny the motion because Davis resides in Dade County. When there are multiple defendants residing in different counties, the case may be brought in any county in which any defendant resides. In this scenario, since Davis resides in Dade County at the time of filing, the court should deny the motion to transfer the case to Broward County. So it's where he reside at the time of filing. All right. Sorry. Oh, sorry. Okay. Assume for this question only that the trial court granted the motion to transfer and the action brought by Payne was transferred to Broward County. Who is responsible for payment of the service charge of the clerk of court to which the action was transferred? Brian only as a party moved for transfer. Brian Davis is defense in the action. Payne is the party who commenced the action, and clerk of the court for Dade County is a transferring jurisdiction. Yeah, see, it's going to be the one who commenced the action. This one I had to accept. You know, that you move for transfer and the person who commenced it has to pay for it. Well, yeah, because it's their action. Payne only as the party commenced the action. Generally, costs associated with the transfer of the case, such as the service charge of the clerk of the court, are responsible for the party initiating the lawsuit. Therefore, Payne, who initiated the lawsuit, will be responsible for this cost. Excellent. West is arrested and charged with first-degree murder and attempted robbery. At trial, the state called the emergency room physician who testified that the victim told him West tried to steal his gold name check. West tried to steal his gold neck chain and shot him. The defense objected and argued that the testimony was inadmissible hearsay. The state argued that the statement that West tried to steal the victim's chain was not hearsay and was admissible as a statement of identification. The state further argued that the statement that the victim was shot was admissible as a statement for purposes of medical treatment. The statement that West tried to steal the chain statement is admissible, and the statement that the victim was shot is inadmissible. The statement that the victim was shot is admissible, and the statement that West tried to steal the victim's chain is inadmissible. Both statements are admissible, both statements are inadmissible. Yeah, shot is admissible because it's medical treatment, but stealing the chain has nothing to do with medical treatment. Excellent. Excellent. The statement that the victim was shot is admissible, and the statement that West tried to steal the chain is inadmissible. Under the hearsay exceptions, the statement that the victim was shot would likely be admissible under the exception for statements made for purposes of medical diagnosis or treatment. The victim's statement to his doctor about being shot directly relates to his medical condition and treatment. However, the statement that West tried to steal the victim's chain does not qualify as a statement of identification. A statement of identification is typically a witness's prior identification of the accused, not a description of the accused's actions. Furthermore, the robbery motive does not relate to the victim's medical treatment, so would not qualify under the hearsay exception either. Therefore, it generally be considered hearsay and inadmissible. Thank you, Ariane. Following the testimony of a physician, the state offered into evidence a copy of the report of the investigating police officer setting forth the officer's observation to scene the crime. The evidence is admissible as recorded recollection, admissible as a public report, inadmissible because it's hearsay without any exception, inadmissible because the original report is required. Definitely inadmissible. We don't like police reports in Florida. I'm going up to Philly to take my test, the UBE. Inadmissible because hearsay now with any exception. The police officer's report falls under the definition of hearsay as is out-of-court statement offered for the truth of the matter asserted in that statement. While there are exceptions to the hearsay rule that allows certain documents to be admitted into evidence, like certain public records and reports, the police officer's reports about observations at the scene of the crime generally do not qualify under these exceptions. Moreover, the officer's observations would likely need to be testified to directly by the officer for the evidence to be admissible. This allows the defense to cross-examine the officer about his observations. If the officer's report were simply admitted without the officer testifying, the defense would be denied this opportunity for cross-examination. So we're not just going to bring in police reports. That's totally hearsay. And in federal law, even if the police report could potentially come in, if what's written on the police report is hearsay, that wouldn't come in either. Hearsay. He said, she said. Nancy Quinn had two sons, Earl Quinn and Brent Quinn, before she married Al Green in 2004. In 2006, Nancy made her first and only will, leaving half her estate to my husband, Al Green, and 1/4 to each of her two sons. On February 15, 2008, Nancy and I were divorced, but Nancy never got around to making a new will. Nancy died on May 1st, 2010, and she was survived by Al, Earl, Brent, and her father, Norman Ritter. Which of the following statements regarding the distribution of Nancy's estate is correct? Since a divorce revokes a will made during coverture, Nancy died intestate, and Earl and Brent will each take 1/2 of Nancy's estate. Earl and Brent will each take 1/2 of Nancy's estate because Nancy's will is void only as it affects Al Green. Since Nancy did not change her will within 1 year after divorce from Al, Nancy's estate will be distributed exactly as stated in her will. Since Nancy's will referred to Al Green specifically as her husband, Al Green will take nothing because he was not Nancy's husband at the time of her death. Earl, Brent, and Norman Ritter will each take 1/3 of Nancy's estate. Yeah, it's B. It's the same thing. Sorry, Al Green. Al Green. Al Green. Is that let's get it on, right? Earl and Brent, I think I'm right. Earl and Brent each take 1/2 of Nancy's estate because Nancy's will is void only as it affects Al Green. Generally, divorce or annulment revokes any provision of will in favor of former spouse. Just an aside, what's the difference between a divorce and annulment? A divorce is like we're ending the marriage. An annulment is we're basically voiding the marriage as if it never happened. Who gets annulments? Celebrities. It's like a real slap in the face to the person you married. Like, nah, we were never even married. This thing is annulled. All right. The rest of the will, however, is not affected. Therefore, the provisions in favor of Earl and Brent are still valid. After revocation of the provisions in favor of Al, Nancy's estate will be distributed as if Al predeceased Nancy. This means that the share of the estate that would have gone to Al under the will instead be distributed to the remaining beneficiaries, Earl and Brent, in equal shares. Hence, each of them will receive half of the estate. Vamos, el próximo. At trial, Good's attorney calls his client to the stand and asks him if Murphy has ever made any offers to settle the dispute. If Murphy's counsel objects, the trial court's proper ruling would be sustain the objection because offers to compromise the claim are inadmissible to prove liability, overrule the objection because the offer was made prior to the filing of a lawsuit, overrule the objection because an offer to pay medical expenses is inadmissible under the Florida Evidence Code, overrule the objection because Murphy's statement was an admission. Yeah, I like that. Inadmissible to prove liability. Compromise. Sustain the objection because offers to compromise the claim are inadmissible to prove liability. Generally, evidence of settlement discussions, including offers to compromise the claim, not admissible in court. This is because public policy encourages parties to freely negotiate and settle disputes without fear of their statements they be used against them if settlement talks fail and the case goes to trial. This rule excludes these statements regardless of whether a lawsuit has been filed yet. The purpose of this rule is to encourage settlements and to prevent the jury from misconstruing an offer of settlement as an admission of guilt or liability. All right, I'm gonna try to read this question presidential. I don't know what president it is. I just kind of mix them all together. Good testifies that his neighbor told him that a friend, a school principal, witnessed the accident and that the principal, still under the stress of excitement of having witnessed it, I can't even do it, of having viewed the accident, had told her exactly what he saw. His attorney then asked Good what the neighbor said. I can't even know what the question said. Good testified that his neighbor told him that her friend, the school principal, witnessed the accident and that the principal, still under the stress of the excitement of having viewed the accident, had told her exactly what he saw. His attorney then asked Good what the neighbor said to him about the accident. Before Good can testify further, Seller interjects a hearsay objection. The court should sustain the objection if the principal is not available to testify, sustain the objection because neighbor's statement is hearsay and no exception applies, overrule the objection because excited utterance exception to the hearsay rule applies, overrule the objection because the spontaneous statement exception to hearsay applies. One person's picking CCC. Yeah, I think this is hearsay. Hearsay? I mean, I'm sorry, I think this is excited utterance exception to hearsay. I did say hearsay, but that's not what y'all picked. All right, well, the answer is B. Sustain the objection because the neighborhood statement is hearsay, no exception applies. I did say I think this is hearsay. I knew I'd get this presidential question wrong. The scenario describes a hearsay within hearsay, double hearsay situation. Each part of the combined statements must separately satisfy an exception to the hearsay rule in order for the combined statements to be admissible. In this case, while the principal statement might be considered an excited utterance, the neighbor's repetition of that statement to Good does not fall under the exception to the hearsay rule. Therefore, the neighbor's statement is inadmissible hearsay. So moving too fast, but excited utterance because it was an excited utterance, but the retelling of that excited utterance is hearsay within hearsay. We're going to have to do this entire quiz over again from the beginning. No, I'm just kidding. All right, let's continue. You get that hearsay within hearsay. He said, she said. Yes, it was excited utterance, but he telling someone about the excited utterance makes it hearsay. Tom and Laura had 3 adult children. After a bitter divorce, Tom was sure Laura would disinherit their son, Biff. Tom executed a new will that provided bequests for all 3 children, but stated, in the event my ex-wife Laura revokes her will in existence on the date of our divorce, I leave my entire estate to my son, Biff. Laura did revoke the will referred to in Tom's will, but did not inherit Biff. At Tom's death, what distribution and reason given below are correct? Tom's estate passes to his 3 children because will provisions are not binding if they're conditioned on events outside testator's control. Tom's estate passes to his 3 children because will provisions are not binding if they're conditioned on future events. Tom's estate belongs to Biff because Laura revoked her will and the provision regarding that event controls distribution. Tom's estate passes by intestate succession because the mistake regarding the contents of Laura's will voids Tom's testamentary intent. Yeah, it's definitely C. It's definitely C. I guess I just gotta be myself. If I try to be someone else, we get the red light. Tom's entire estate belongs to Bill because Laura revoked her will and the provision regarding that event controls distribution. Tom's will explicitly states that the entire estate should go to Biff if Laura revokes her will. Despite the bitterness of their divorce, Tom's testamentary intentions, as explicitly stated in his will, control distribution of the estate. The condition upon which the entire estate would pass to Biff has occurred, Laura revoking her will, and hence, according to Tom's will, the entire estate should go to Biff. The fact that Laura did not disinherit Biff in her new will does not affect the provision of Tom's will. The specific content of Laura's new will was not a condition in Tom's will. Okay. Back in the green. Before Sue and Harry were married, Harry signed an agreement waiving all claims to Sue's estate. Harry received advice of counsel prior to signing the agreement. After Sue dies, Harry learned for the first time that Sue owned over $1 million worth of stock. Sue's validly executed will leaves her entire estate to her mother. Which of the following is true? Harry is entitled to homestead property because he did not specifically waive his right to homestead. Harry is entitled to his elective share of Sue's estate because he did not make a fair distribution of her estate. Harry is entitled to the family allowance because family allowance cannot be waived. Harry is not entitled to any share of Sue's estate. Yeah, I'm sorry, Harry. You're not going to get anything here. Wait, we have a B. No, elective share because you not make a fair disclosure. We have an A, not specifically Rose's right to homestead. Wait, scroll up. Good thing we slowed down on this one because now we have 3 different answers, and I gotta make sure. Before Sue and Harry were married, Harry signed an agreement waiving all claims to Sue's estate. Harry received advice of counsel prior to signing the agreement. After Sue dies, yeah, I think it's D2. I think Harry's out of luck. He waived all claims. D. Let's try D. Yeah. All right, good. Harry's not entitled to any shares to the estate. In this scenario, Harry signed an agreement waiving all claims to the estate. This suggests that he gave up his right to property, including potential future inheritance rights. Even if he did not know the exact size or value of Sue's estate at the time, the fact that he received legal advice prior to signing the agreement further supports the validity of the waiver. As such, he would not be entitled to any share of Sue's estate after her death. So you can, who does anyone know who can't disinherit, who can't disclaim?
Children.
Indigent,
Insolvent?
yeah. Insolvent, that's the word I was looking for. Insolvent. If you're insolvent, you can't disclaim. Or if you've already used the proceeds in a beneficial way. But if this particular person already disclaimed, it's too late. They disclaimed. All right. During a depo, upon oral examination, a party's counsel may instruct the deponent not to answer a question for which the following reasons. The question asked for hearsay testimony that be inadmissible at trial. The question asked for evidence protected by a privilege. The question asked the deponent for opinion concerning the ultimate legal issue in the case. None of the above. Yeah, definitely B. Definitely B. Confidence is back in. We're rolling in. Hearsay within hearsay. If we're going to get one question wrong, it's fine. Hearsay within hearsay. The question asked for evidence protected by a privilege. During a deposition, a lawyer may instruct the witness not to answer a question if the information being sought is protected by legal privilege, such as attorney-client privilege or doctor-patient privilege. These protections exist to ensure that certain types of sensitive information can be shared in confidence and are not subject to disclosure during the discovery process or at trial. Note that hearsay rules and limitations of expert testimony do not apply to depositions as they do in trial. Let's continue. Joan is seriously injured in an automobile accident at 7 a.m. June 22nd. That's weird. I was just listening to a song called June 22nd. I'm not making that up. Sunrise on that date was 6:22 a.m. Joan brings suit against Sam, the driver of the other car involved, alleging his failure to have his headlights on caused the accident. Sam, in support of his claim that his failure to have his headlights on was not negligent, requests that the judge take judicial notice of the fact that Section 31627 Florida statutes requires the use of the headlights only between sunset and sunrise. Sam did not notify Joan prior to trial that he would make this request. The court may take judicial notice if Sam shows good cause for his failure to notify Joan of intention to make this request, and both parties are given the opportunity to present relevant information regarding the request. Must take judicial notice because it's public statutory law of Florida. Must take judicial notice as it is not subject to dispute because it's generally known within the territorial jurisdiction of the court. May not take judicial notice because Sam failed to give Joan timely notice of his intention to seek judicial notice of the fact of trial. We have a lot of different answers here. But I think this is, I agree with Amy and Nicole. I think this is statutory public law of Florida. Let's go with B as in basketball. Basketball. B must take judicial notice because it's public statutory law of Florida. In many jurisdictions, judges are obliged to take judicial notice of the law of the jurisdiction, meaning they must apply and consider the law as it is without requiring parties to prove it. In this case, Sam is requesting the court to recognize the specific provision of Florida statutes. As this is public law of Florida, the court must take judicial notice of it. The requirement of notification before trial would generally apply to adjudicative facts, not legislative facts like statutory law. Excellent. The Articles of Incorporation for number one corporation grant to its board of directors the power to take any action as authorized by law. Which of the following actions by the board of directors must also be approved by the shareholders of number one corporation? Extension of the duration of number one corporation if it was incorporated at a time when limited duration was required by law. Merger of number one corporation into another corporation with the other corporation becoming the surviving corporation. Changing of the corporate name to number one Inc. Changing the par value for a class of shares of number one corporation. Yeah, merger. Merger of number one corporation to another corporation with the other corporation becoming the surviving corporation. Generally, a merger, particularly one in which the corporation ceases to exist as an independent entity, is considered a fundamental change. Under corporate law, fundamental changes typically require the approval of shareholders because they significantly affect shareholder rights. The other options, extension of corporate duration, changing the corporate name, or changing the par value of shares, usually can be carried out by the board of directors without shareholder approval unless the corporation's bylaws or AOI specify otherwise. Thank you all for sticking with me tonight and every night. Well, this is actually our last night together. It's kind of sad. We have one more morning, but this is our last night. I mean, if you want to be back in February, you can. I'll be here. Husband confesses to wife that if you really want to see me, just bomb the test and then you can hang out with me for a whole nother class. Husband confesses to wife that husband robbed bank of 200. 2 years later, husband physically abuses wife. Ooh, sounds like Jonah Hill. Wife later files for divorce and seeks custody of child. After the hearing, wife seeks to testify as to the robbery discussion. Husband may prevent wife from testifying because the husband-wife privilege, prevent wife from testifying as statute of limitation of robbery is expired, not prevent wife from testifying because only wife can assert the husband-wife privilege, not prevent wife from testifying because this is a proceeding brought by one spouse against the other. Definitely D. You can't use the privilege if it's against each other. It's the same with attorney-client privilege. Not prevent the wife from testifying because it's a proceeding brought by one spouse against the other. In Florida, the spousal communication privilege, which allows a spouse to refuse to testify about confidential communications made during the marriage, does not apply in cases brought by one spouse against the other. This exception is especially prevalent in cases involving domestic abuse or divorce proceedings. Therefore, in this case, husband cannot prevent wife from testifying about the robbery confession. In a pretrial motion, the defendant argues there are no genuine issues of material fact. That sounds like summary judgment. Let's click C. No genuine disputes of material fact. That sounds like summary judgment. Let's pick C, right? In support of the motion, the defendant cheated several affidavits from witnesses, which is the correct caption for the case. Motion to dismiss for failure to state a cause of action. Motion for judgment on the pleadings. Summary judgment. Let's pick C. Motion for directed verdict. Look for that. No genuine dispute of material facts. Summary judgment. Judgment is a pretrial motion where the moving party argues there are no genuine disputed material fact and that they are entitled to judgment as a matter of law. This type of motion is usually supported by evidence outside of pleadings, such as affidavits, depots, or other documentary evidence. There are other types of motions, and the options generally do not consider such external evidences. Right, the pleadings is just going to be straight looking at the pleadings, and this was going to be discovery, and it would be summary judgment. I alluded to this earlier about ripping up the codicil. Jill makes a will. Jill makes a will, leaving all of her stocks to Lou and the rest of her estate to Beth. Several weeks later, she creates a codicil to the will that divides her jewelry to Anne. Jill and Beth have a fight, and Jill mistakenly rips up the codicil rather than the will. Nothing happened. Jill dies. Which of the following is true about the distribution of Jill's estate? Beth receives the jewelry pursuant to the terms of the will. Jill's estate will be distributed as intested property because Jill revoked her will. Anne receives the jewelry under the terms of the codicil, or none of the above. It's going to be C, right? Nothing happened here. There was a will, there was a codicil, there was no revocation because there wasn't an alignment of physical act and intent. Anne receives the jewelry under the terms of the codicil. If Jill mistakenly destroyed the codicil thinking it was the will, then the codicil may still be considered valid since it was not destroyed with the intent to revoke it. Therefore, Anne would still receive jewelry under the terms of the codicil. The concept of dependent relative revocation may also apply here, which could allow the codicil to remain valid if the court finds that Jill would not have it revoked if she had known she was not also revoking the will. I'm laughing right now because that's one of, like, I told everyone you should have an anxiety list. And for me on the UBE, that was one of the words, DRR, dependent relative revocation. They tested on the UBE. I don't think they tested much on Florida. During defendant's first degree murder trial, the state calls witness to testify. Witness testified that the defendant was not the man she saw shoot the victim. During the investigation of the murder, witness told prosecutor that she saw defendant shoot the victim. This prior statement was made under oath and was recorded by a court reporter, but defendant's attorney was not present. If the state seeks to introduce witness's prior inconsistent statement for the sole purpose of impeaching witness, should the court allow the prior statement to be admitted into evidence? Yes, because any party can attack the credibility of a witness by introducing prior inconsistent statement. Yes, because a prior inconsistent statement given under oath can be used by any party for any purpose. No, because the state cannot impeach its own witness with a prior inconsistent statement. No, because defendant did not have an opportunity to cross-examine witness at the time the statement was made. Yeah, definitely A, right? Any party can attack the credibility of a witness by introducing a prior inconsistent statement. B is too broad. B isn't broad. Yes, because any party can attack the credibility of a witness by introducing a prior inconsistent statement. In general, a party can impeach their own witness. This is known as impeachment with contradiction, where the goal is to show that the witness in court testimony is unreliable. This can be done through the use of a prior inconsistent statement, even if it's given under oath. The main purpose is not to introduce it as substantive evidence, but to question the credibility of the witness. As the main goal is impeachment and not the introduction of hearsay statement for truth, the lack of an opportunity of cross-examination at the time can you all still hear me? Yeah. As the main goal is impeachment and not the introduction of hearsay testimony for truth, the lack of an opportunity of cross-examination at the time the statement was made is not typically a barrier to its use for impeachment purposes. I think the person who's watching my dogs when I go take my bar in Philly is coming, so I'm gonna make him wait. I'm sorry. I care about my students. I care about my dogs more than my students, not gonna lie. But right now, I'm gonna lock it in for you guys. I love you all, but my dogs, come on. Tap Inc. has fewer than 100 shareholders. The shareholders wish to enter into an agreement pertaining to the exercise. Oh, perfect. We'll be here in 15. The shareholders wish to enter into an agreement pertaining to the exercise of the corporate powers or the management of the affairs of the corporation. Which of the following, if adopted by shareholders, will be contrary to public policy and therefore unenforceable in Florida? An agreement that exculpates directors from all personal liability, an agreement that authorizes a particular shareholder to manage the affairs of the corporation, an agreement that requires the dissolution of the corporation at the request of one of the shareholders, an agreement that eliminates the board of directors. Definitely A is an applesauce, A is an Andrew, right? You can't exculpate liability from a director. That's going to be against public policy. An agreement that exculpates directors from personal liability. Florida provides for certain fundamental responsibilities and obligations for directors, which they cannot be exonerated from. These often include duty of loyalty and care, and responsibility for overseeing the proper management of the corporation. While the directors can be indemnified from liabilities arising from certain activities, as a director, they cannot be fully exculpated from personal liability. This would be contrary to public policy. Options B, C, and D are typically allowed under closed corporations or shareholder agreements, depending on the specific laws of the jurisdiction. El próximo, por favor. In a timely post-trial motion, defendant argued for the first time that the trial court lacked SMJ over the case. What action should the court take? Entertain the motion because SMJ can be brought at any time. entertain the motion because the defendant can assert lack of SMJ as long as it's raised within 10 days of the judgment. Refuse to entertain the motion because defendant did not raise lack of SMJ in its answer. Refuse to entertain the motion because defendant did not raise lack of SMJ at trial. Definitely A. We're going to track 12B rules of federal law in Florida. It's going to be the same. 12B1, 6, and 7 can be brought at any time. SMJ can be brought at any time. This is because SMJ refers to a court's power to hear and decide a particular type of case. If a court does not have SMJ over a case, then any judgment rendered is void. Because of this severe consequence, the issue can be raised at any point. Excellent. Excelente. Oh yeah, earlier I was talking about Speedy Gonzalez, if anyone knows who that was. And I just saw this episode with him and Slowpoke Rodriguez, and it's like the stuff they used to get away with in the 90s. Smith and Jones had planned to form a Florida corporation that would have done business as an engine repair shop. No paperwork had been filed with the Secretary of State relating to the corporation when Smith and Jones began to purchase equipment needed for the engine repair business. Together, they executed and delivered a $10,000 promissory note to seller in the name of Engine Repair, signed by Smith as president and Jones as secretary of that non-existent corporation. There was no personal guarantee by either Smith or Jones on the note. The corporation was never formed. Seller learned the corporation was not in existence only after the debt was not timely paid. Smith was in bankruptcy by that time, and seller sued Jones personally for the entire $10,000. Jones moved to dismiss. In its ruling, the court should grant the motion because Smith is an indefensible party, grant the motion to dismiss because Jones did not personally guarantee the note, deny the motion because Jones signed the note purporting to act on behalf of the corporation with actual knowledge of its non-existence, deny the motion because Jones' actions effectively created a corporation by estoppel. Tough question, two really good answers, but one better answer. Yes, C is better than B. Let's see why. I see, said the blind man. My brother used to always say that. That was like his thing because of like the absurdity of it. Deny the motion because Jones signed the note purporting to act on behalf of the corporation with actual knowledge of its non-existence. This is a situation known as acting for a non-existent corporation, where an individual who signs a contract on behalf of a corporation which he or she knows does not exist can be held personally liable. Smith and Jones knew the corporation was in existence when they signed the note, and thus they can be held personally liable for the debt. Even though there wasn't a personal guarantee in the note, because Jones acted as if the corporation existed, he could still be liable. You guys make me laugh. I'm thinking about the texts I get from my students throughout the day are insanely hilarious. Raymond had a valid Florida will devising his entire estate to his friend Jake. Raymond and Jake had a fight, and Raymond then executed a second valid will, devising his entire estate to charities and expressly revoking the first will. Years later, Raymond and Jake reconciled, and Raymond burned the second will. Raymond later died. Does Jake inherit the estate? Shout out to Jake, the person who put this all together. Yes, because the burning of the second will was an effective act of revocation, reviving the original will. Yes, because Florida law is construed to avoid intestacy. No, because burning the second will was an insufficient act of revocation absent additional evidence. And no, because revocation of the second will does not revive the first one. I agree with D. Sade, are you from Trinidad, like Alexis?
Half and half. Sorry, I
Yeah.
did not mean to
No,
answer
it's-
the question before. I'm so sorry.
No,
I was on
you're good.
autopilot.
No, Trinidad, people from Trinidad are like my favorite people, very hardworking people from what I've experienced. I have a lot of people on my staff from Trinidad, especially Alexis. Alexis is the best.
Awesome.
Revocation of second will does not revive the first one. Under the law, the revocation of second will does not automatically revive the first will. The first will can only be revived as re-executed or if it's codicil in conformance with statutory formalities. Therefore, Jake would not inherit in the first will, and Raymond's estate would likely pass la la. So understand that a revocation of one will is not going to reactivate another will, right? All right, let's do the next one. Plaintiff filed a civil complaint against defendant 4 years ago. This complaint was voluntarily dismissed 3 years ago. 2 years ago, plaintiff filed the complaint again and voluntarily dismissed it last year. May plaintiff successfully file a complaint again this year? Yes, if the statute of limitations has not run. Yes, if the most recent complaint arose out of the conduct, transaction, or occurrence set forth in the previous complaints. No, because the second voluntary dismissal operates adjudication on the merits. No, because the most recent complaint is a supplemental pleading requirement permission. Supplemental pleading requiring permission of the court prior to filing. Yeah, like CCC. Holy people calling me. C as in caterpillar, C as in cat, yes. No, because the second voluntary dismissal operates as adjudication of the merits. A plaintiff can voluntarily dismiss an action without a court order by filing a notice of dismissal before the opposing party serves either an answer or motion for summary judgment. However, if the plaintiff has previously dismissed any federal or state court action based on or including the same claim, a notice of dismissal operates as an adjudication on the merits, effectively ending the plaintiff's ability to bring the claim again. Oh my God. My boxing trainer's outside my house saying, I heard you're not injured anymore. And he wants to get working. I love that. Mary, a widow, died in Orange County, Florida during a visit with her son, James. Mary had executed a will leaving all of her property to James. Prior to her death, Mary lived in a rented apartment in Duval County, Florida, but owned vacant land in DeSoto County, Florida. Mary also had a vehicle loan due in Dade County, Florida. In which of the following counties can Mary's will be probated? Orange County, Duval County, DeSoto County, or Dade County? Where's the property? Died in Orange County. And she lived in Duval, lived in a rented apartment on vacant land in DeSoto County.
Wait, Ariane, can you scroll down? Yeah.
Yeah, can you scroll down? Where are they domiciled? Where's she domiciled? She's domiciled in Duval? Duval? Yeah, I'm going with domicile. B. I don't know why, if you ever go to Jacksonville, they love that. Duval. I swear. The general rule is that probate proceedings should take place in the county where the decedent was domiciled at the time of death, right? Where they're domiciled at the time of death. That's where probate is. Mary was living in Duval, and therefore Duval is the proper location for probating her will. The county where death, Orange, the county where she owns real estate, DeSoto, and the county where she has debt are not generally relevant to the determination of where the will should be probated, right? Probate is where you're domiciled. No, you're fine, Ariane. Ariane could be, well, we'll see. I would love for Ariane to be an instructor for Ibis Prep. She knows her stuff. But the problem is that most of the best people who would be great instructors for Ibis Prep would also be great attorneys. And so it's hard to retain. Dennis was charged with burglary and grand theft. At trial, Dennis called his wife and case in chief to testify that Dennis was known throughout the area where they lived as an honest person. The prosecution objected. The testimony is admissible as character evidence, admissible as impeachment of the alleged victim, inadmissible as improper opinion testimony, or inadmissible as improper reputation testimony. Yeah, let's bring it in. Dennis. Very reputable. As per Florida statute 90.401, an accused person is permitted to offer evidence of pertinent character trait, in this case, honesty. Dennis's wife's testimony's reputation for being an honest person in their community is admissible character evidence to help show he's unlikely to commit the offenses of burglary and grand theft. Excellent. Plaintiff alleges that injuries were sustained when a stack of canned goods fell on her in defendant's supermarket. During his defense, the supermarket attempts to offer testimony tending to show the procedure of his supermarket as to displaying and piling canned goods for the consideration of the jury on the question of negligence. Under the Florida Evidence Code, the evidence is irrelevant. The evidence is admissible only if corroborated by written policy or procedure addressing this practice. The evidence is admissible if it's a routine practice of the supermarket. The evidence is admissible only if there's a university accepted method used in the trade. Sounds very like routine practice-y to me. Let's hit it with the C. C. Admissible routine practice is the application of Rule 406, which corresponds with the federal Rule 406, which basically says that routine practices of displaying and stacking canned goods will be admitted to prove that in a particular occasion the organization acted in accordance with the routine practice. The supermarket's methods of displaying and stacking canned goods would be highly relevant to the question of whether it acted negligently in this particular case. Thank you so much, Gabby. Continue to do these questions on your own. And like I said, do these questions during lunch before you take the multiple choice questions. And I'm sure I'll be seeing you tomorrow. All right, number 46. Toy Makers Inc. is a Georgia corporation transacting business in Florida. Until it obtains a certificate of authority to transact business in Florida, which of the following activities is Toy Makers prohibited from doing in Florida? Maintaining a proceeding in any court in Florida, defending a proceeding in any court in Florida, obtaining orders by mail from Florida residents which require acceptance in Georgia, selling his product through independent contractors in Florida. For sure. We can defend, but we can't maintain if we're a foreign corporation. A foreign corporation just means someone who's not incorporated. Maintaining a proceeding in any court in Florida, foreign corporations, which in this context means people not incorporated in Florida, are generally required to obtain a certificate of authority from the Florida Department of State in order to transact business in Florida. Until to obtain such a certificate, a foreign corporation is prohibited from maintaining a proceeding in any court in Florida. Frank was arrested. Come on, Frank. Frank was arrested and charged with a felony. In response to his attorney's request for discovery, the state should provide certain information, which the following is the state not required to produce: results of physical or mental examinations, scientific tests, experiments, or comparisons, all portions of recorded grand jury minutes that pertain to Frank's case, all tangible papers or objects that the state intends to use to trial, whether the papers came from Frank or not, the names and addresses of all persons known to have any information that may be relative to offense charged. What are you gonna do, Frank? You gonna shoot me in front of all these people? Yeah, B. Anyone know where that's from? All portions of recorded grand jury instruments that pertain to Frank's case under Florida Rules of 322 and consist of the general practice in many jurisdictions. Grand jury proceedings are usually secret, and transcripts of the proceedings are not typically part of the discovery process provided to the defense unless the testimony will be used to impeach a witness, which is exculpatory, or there's some other compelling reason. What are you gonna do, Frank? You gonna shoot me in front of all these people? As American Gangster. I quote a lot of Denzel Washington movies. Dan was served with a subpoena to appear and testify at civil trial by a 19-year-old process server. The process server lied about his age to get the job. Hey, man. So did Mila Kunis when she was in that 70s show. The subpoena was issued by an attorney of record in the case and not by the clerk of court. Dan would rather stay home than attend the trial. Wouldn't we all? Dan consults with his attorney to find out if he must comply with the subpoena. The attorney should tell Dan to comply with the subpoena to avoid the risk of being held in contempt by the court, object to the subpoena because it should have been issued by the clerk of court, not the attorney in the case, object to the subpoena because it was served by a 19-year-old, and under Florida law, a process server must be no less than 20 years of age, object to the subpoena because the subpoena can only be used to compel an individual to appear for deposition or produce documents. Yeah, hey, you better comply with this, or you're gonna be held in contempt. Let's see what it says. Comply with the subpoena or avoid being held in contempt. In Florida, allows attorneys of record action to issue subpoenas. So the subpoena being issued by an attorney is not improper. As for the age of the process server, Florida statute does not specify a minimum age for process servers. It only requires that the process server be appointed by the sheriff. The fact that the process server lied about their age does not invalidate the service of the subpoena. Next, please. Thank you, next. It's Ariana Grande. And I had a student that used to always say that after every question. Thank you, next. Peter is the named plaintiff. I've been doing this for so long. Peter's the named plaintiff in a class action lawsuit alleging that a local cell phone store has engaged in unfair or deceptive trade practices in its sale of cell phones. In the complaint, Peter sought damages on behalf of himself and class action of all the customers who provide cell phones from the store. In order for Peter to maintain the class action, the court must find the class members' claims contain no questions of law or fact that affect only individual members of the class. Peter can fairly and adequately protect and represent the interests of each class member. Allowing separate claims from individual class members risk inconsistent or varying adjudications or none of the above. I'm gonna go with B, Peter. Peter can fairly and adequately protect and represent the interests of each class member. The statement mirrors a requirement found of the Florida Rules of Civil Procedure, which requires that the representative parties will fairly and adequately present the interests of the class. I think Peter and Andrew were brothers in the Bible, so our names are linked. Leon died intestate owning Florida homestead. Peter just texted me. How crazy is that? One of my MB students. Leon died. That's crazy, right? Leon died intestate owning. I don't know. That is really tripping me out right now. Like literally that exact moment. Good old PD, my man. Leon died intestate owning Florida homestead property titled to his own name. He resided on the property for many years prior to his death. He is survived by his widow, Charlotte, and an adult son by his earlier marriage, Bob. Leon purchased the homestead property with his own funds during the time of the marriage to Bob's mother. Proper disposition of the homestead property is fee simple to Charlotte. Bob and Charlotte as tenants in common. Life estate to Charlotte, vested remainder to Bob. Bob and Charlotte as joint tenants with right to survivorship. Yeah, it's gonna go life estate to Charlotte, vested remainder to Bob. Everyone listen up carefully for this one. Under Florida law, if a decedent dies intestate and owns homestead property, the proper disposition of the property depends on whether the decedent is survived by a spouse and or minor children. If there's no minor child, then the surviving spouse, in this case Charlotte, takes a life estate of the homestead property with the vested remainder to descendants per stirpes. M Corp's only assets are machines now in storage. One of its directors is approached by a party interested in buying all the machines, which is true regarding the sale of assets. The board must consult with shareholders, but can sell the machines. Can sell the machines. M Corp's only assets are machines now in storage. One of its directors is approached by a party interested in buying all the machines, which is true regarding the sale of the assets. The board must consult with shareholders, but can sell the machines even if a majority of shareholders recommends against the sale. A majority of the shareholders entitled to vote on the matter must vote in favor before M Corp could sell the machinery. The proposed transaction does not implicate the shareholders' appraisal rights. 2/3 of the board of directors must vote in favor before M Corp can sell the machinery. People are picking B because they understand that this is actually a liquidation event because they said they sell all of their assets, right? All right. Let me see. The majority of the shareholders entitled to vote in the matter must vote in favor before M Corp. In Florida, generally a sale, lease, exchange, or other disposal of all or substantially all the property of a corporation requires approval from the board of directors and the shareholders. However, there are exceptions if in the usual regular course of business. Here, the corporation's only assets are the machines, implying that would constitute a sale of substantially all the corporation's property. Therefore, they can sell the machinery. It seems to be the most fitting response based on Florida's Corporation Act. So it means that if it's a liquidation event, it's a takeover, it's a merger, it's a stock split, it's voting for new directors, we do need a vote. Just lock in. Everyone, I'd like to tell them the whole story about finishing strong. And, you know, most people die within a mile of being saves. That was my coach, Jeff Madden. The court referred a civil case for mediation on April 1st. On April 10th, the mediator set an initial mediation conference on April 30th. Plaintiff's attorney served a set of interrogatories 1 week before the case was referred to mediation, which is true. Referral to mediation told the time for defendant to respond to plaintiff's interrogatories from April 10th to April 30th. Defendant did not have to respond to the interrogatories until the mediator declared an impasse. The referral to mediation automatically added 30 days to the time period to respond to any discovery. The referral to mediation did not affect the time period for defendant to respond to defendant's interrogatories. Yeah, D, there's no change. The referral to mediation did not affect the time period for the defendant to respond to plaintiff's interrogatories. In Florida, the rules for civil procedure and time to respond to interrogatories, 30 days under Rule 1.340 of the Florida Rules of Civil Procedure, are not altered or paused told due to mediation. Mediation and discovery are generally separate processes that do not affect the other. William, who solely owned a legal homestead, passed away, leaving Lynn, his spouse, and Christopher, their mild child. In his will, William left the homestead to his disabled cousin Daisy so that Daisy may have a safe place to live. Watch out for them making you feel emotional or sentimental. Daisy, so that Daisy may have a safe place to live. Lynn contested the devise of the homestead, how the court ruled. By allowing the homestead to pass to Daisy, by allowing the homestead to pass to Daisy as a life estate with the remainder to Lynn, by awarding the homestead to Lynn, or by awarding the homestead to Lynn and Christopher in equal shares. It's definitely C. We might have an issue with the answer here, but it's definitely C. All right, nice. Good job, Jacob. By awarding the homestead to Lynn, the Florida Constitution restricts the ability of the homeowner to devise the homestead property if they're survived by a spouse or minor child, except the homestead property may be devised by the owner's spouse if there's no minor child. In this case, William attempted to devise his homestead property to his cousin Daisy, but he survived by a spouse, Lynn, and a minor child, Christopher. This is not allowed under Florida's homestead law. Therefore, the devise to Daisy would not be effective. Under Florida statutes, if not devised as permitted by the law, under the Florida Constitution, the homestead shall descend in the same manner as other intested property. However, if the decedent is survived by a spouse and one or more decedents, the surviving spouse will take a life estate in the homestead with a vested remainder to the decedents in being at the time of the decedent's death per stirpes. But Florida statutes give the surviving spouse a right to elect to take an undivided 1/2 interest in the homestead as a tenant in common, with the remaining undivided 1/2 interest vesting in the descendants in being at the time of the decedent's death per stirpes. In summary, Lynn could either take a life estate with the remainder to Christopher or elect to take a 1/2 interest as a tenant in common with Christopher. The property cannot pass to Daisy under Florida's homestead laws. Very good question and answer. An explanation, if I do say so myself. Okay, Mary's grandmother, Helga, died several weeks ago. Mary knows her grandmother had a will, but she cannot find it, nor can she find a copy of it. She knows that her grandmother left her a rather large portion of her estate valued at $3 million. Which of the following is correct? Since the will cannot be found, the law will treat Mary's grandmother as if she died intestate. The content of the will can be proved through Mary's testimony. The content of the will must be proved by the testimony of at least one disinterested witness, or the content of the will must be proved by the testimony of at least two disinterested witnesses. Yep, two disinterested witnesses. I saw this funny meme. It was like two male lions going into Noah's Ark together, and the meme was like, they're gonna have a hard time meeting. The content of the will must be proved by the testimony of at least two disinterested witnesses. Under Florida law, if a will is lost or destroyed and it was last in the possession of the decedent and was not found after their death, is presumed to have been revoked by the decedent. However, this presumption can be rebutted. The contents of the will and its execution can be proved by the testimony of two disinterested witnesses. Again, a lot of great stuff from this. Paula is the mother of 3 children. One child, William, shares Paula's passion for flying. Paula is no longer married to the 3 children's father, Harry. When William reached 18 years of age, Paula gave William her biplane worth $120,000 and said to William, I know you love this plane. I give it to you now in advance since you inherit the plane one day anyway. Be careful about that sentence. Paula subsequently died without leaving a will. At her death, her estate was worth $240,000, which is true regarding the disposition of Paula's estate. Each of Paula's children will receive $120, except for William, who will get nothing. Each of Paula's children will receive $80. Harry will receive 20 plus 1/2 of the residue of the estate, and the 3 children will share the other 1/2 of the residue equally. Harry will receive 20 plus 1/2 of the residue of the estate, and the children, except for William, will share the other 1/2 equally. Yes. Ariane, be careful. Last time you just clicked it. Each of Paula's children receive $8,000 under Florida's law. If a person dies intestate without a will and is survived by a decedent but not a spouse, then the entire estate goes to the decedents. In this case, Paul died without a will, is not survived by a spouse, and has 3 children. Therefore, each of the 3 children will inherit an equal share of her estate. Paula's gift of the plane to William was a gift during her life, not a testamentary gift. The gift of the plane does not count against William's share of Paula's estate after she dies without a will. Beautiful. Plaintiff sued defendant for conversion of stock certificates of ABC Corporation. During the subsequent civil trial, plaintiff orders into evidence a copy of the New York Times to establish the price of ABC stock on the day of the alleged conversion. Defendant objects on the grounds of hearsay. Assuming that the trial judge overrules the hearsay objection, what evidence, if any, would plaintiff need to present to authenticate the newspaper? No evidence is required because the court overruled the hearsay objection. No evidence is required because the document is self-authenticating. Authentication must be established by introduction of the document accompanied by an affidavit from a records custodian of the newspaper. Authentication must be established by introduction of the document through the testimony of a witness with knowledge that the document is what it claimed to be. The answer is B, because newspapers are indeed self-authenticating. Exactly. No evidence is required because the document is self-authenticating. On the Florida Evidence Code, certain documents are considered self-authenticating. This means they require no additional evidence to prove their authenticity. The self-authenticating documents include domestic public documents under seal, domestic public documents not under seal, foreign public documents, certified copies of public records, official publications, newspapers and periodicals, trade inscriptions and the like, acknowledged documents. Newspapers fall into this category of self-authenticating evidence. Andy and Donna form an LLC and the only members. Andy contributes attractive commercial real estate to the LLC. Donna contributes $150,000, which is true. Andy and the LLC are co-owners of commercial real estate. Donna and the LLC are co-owners of any property that's acquired with the 150. The LLC is the sole owner of the commercial real estate and any property that's acquired with 150,000. None of the above. Definitely C, right? LLC, like Ibis Prep. We don't own any property, but one day we will. The LLC is the sole owner of the commercial real estate and any property that is acquired with 150,000. Under the laws governing LLCs in Florida, any property or assets contributed to LLC by its members becomes a property of the LLC itself. Once the property is transferred to the LLC is the sole owner of that property. The members do not retain any direct ownership interest in the contributed assets. You know, something that I really thought about when I started my business, the biggest hotel company, Airbnb, doesn't own any property. The biggest car rental service company, Uber, doesn't own any cars. And the biggest educational tutoring company doesn't have any books, materials, or classrooms. We're talking about the future. Scott, Joyce, and Mitch formed a member-managed LLC. On January 1st, Mitch dissociated from the LLC. 2 years later, Mitch sent a demand letter to the LLC seeking to review the LLC prior year's federal income tax return. In his demand, Mitch provided 10 days notice to review the records at the physical address of the company at 1 p.m. The LLC refuses to provide Mitch with this information. What is the LLC's best argument for not providing the information sought? Mitch is no longer a member of the LLC. The tax return does not pertain to the time period when Mitch was a member. The demand does not provide for sufficient notice. None of the above. The LLC must allow Mitch to review the records. Definitely like B, you can't get records from a time period in which you were not a member. I really appreciate all the people who are staying up and participating. You guys are going to crush this Florida multiple choice section. I believe that. Tax return sought does not pertain to the time period when Mitch was a member. Under Florida law, a person associated from LLC retains the right to access and inspect the records of the company during the period in which they're a member. If the tax return Mitch is seeking does not pertain to the period during which he was a member of the LLC, then the LLC is not obliged to provide him with this information. This is regardless of whether or not Mitch is a current member, as his rights to access information pertain to the time period during which he was a member of the company. Beautiful. Henry is charged with criminal mischief for destroying his wife Whitney's car. At trial, Whitney testifies that while in bed one night, Henry admitted destroying her car because she accidentally scratched her car. Now you probably keyed it up. Henry objects to his testimony as protected under the husband-wife privilege. The court will sustain the objection only if Henry reasonably expected that statements to Whitney was confidential. Sustain the objection because the husband-wife privilege allows Henry to prevent Whitney from disclosing the statement. Overrule the objection because Henry is charged with a crime against his spouse's property. Overrule the objection because Whitney voluntarily disclosed the communication and waived that husband-wife privilege. Definitely C. They tested this twice now, right? It's the marital privilege will be waived if it's crimes against the other spouse. The other thing they tested twice, newspapers are self-authenticating. Am I going to gamble that both of these questions are going to appear in some very similar shape or form on test day? With my bottom dollar. Overrule the objection because Henry, whatever. We already know that. It's crime against property. Don't worry about it. Ava, Billy, and Courtney were traveling in the same car when a pickup truck hit their car. Don't worry, Ariane. You're fine. You're doing an amazing job. Me and you have a career together. I've always wanted to be a game show host, and you could be my Vanna White. They were injured in the accident. Each filed a separate action against Della, the driver of the truck. Before trial, Della moved to consolidate the 3 actions into one trial. Ava consented, but Billy and Courtney objected, which is true. The court cannot consolidate 3 actions over the objections of Billy and Courtney. The court cannot hold separate trials on damages if it holds a consolidated trial on liability. The court can consolidate the 3 actions if all plaintiffs consent. The court can consolidate the 3 actions that involve common questions of law or fact, and consolidation would not deprive a party of a substantive right. D. The court can consolidate the 3 actions that involve a common question of law or fact, and consolidate would not deprive a party of a substantive right. The Florida rule allows the court to consolidate actions that involve a common question or law of fact for the convenience of the parties of the court and to avoid unnecessary cost or delay. Consent of all parties is not required, and the court has direction to consolidate the actions, but it must ensure that the consolidation does not deprive any party of a substantive right. The court will weigh considerations such as avoiding redundant evidence and ensuring a fair and efficient trial process against potential prejudice to any party. Daisy was charged with driving under the influence after she crashed into Pete's car. Daisy offered to plead guilty to a reduced charge of reckless driving. You see, they even repeat the same names, Daisy, Henry, like they're not that creative. They're gonna repeat questions on test day. Probably named Daisy. Daisy offered to plead guilty to a reduced charge of reckless driving. The state and Daisy did not reach an agreement and went to trial. Daisy was acquitted. Pete sued Daisy for damage arising from the crash. At the civil trial, Pete's attorney asked Daisy if she offered to plead guilty to any criminal charge relating to the crash. Daisy's attorney objected, which is true. The offer to plead guilty is admissible because it's not offered for the truth of the matter asserted. The offer to plead guilty is admissible because it's admission by a party opponent. The offer to plead guilty is inadmissible unless Daisy is unavailable to civil trial because of the declaration against interest. The Florida rules of evidence state that offers to plead guilty are inadmissible. Wait. All right, good. Sorry, I had to think about it, but all right, Ariane, I trust you now. The Florida rules of evidence state that the offers to plead guilty are inadmissible. This rule is set out in Florida rules of procedure. Florida rules of evidence, which state that except as otherwise provided, evidence of a plea of guilty withdrawn, or nullo contendere to the crime charge or any other crime is inadmissible in any civil or criminal proceeding. As such, Daisy's offer to plead guilty to reduced charge of reckless driving would generally be inadmissible as evidence in Pete's subsequent civil lawsuit against her damage related to the car crash. The rationale behind this rule is to encourage open discussion and plea negotiations in criminal cases, without fear that these discussions might later be used against the defendant if a plea agreement is not reached and the case goes to trial. All right. At 10 a.m., January 15th, a drugstore, Prescriptions Inc. was robbed by two armed men wearing red handkerchiefs over their faces. A medicine bottle containing narcotics pills, along with 148 in small bills, was stolen. Steve was picked up, searched, interrogated, and fingerprinted. Steve's fingerprints matched those found at Prescriptions Inc. During his deposition, Charles, a clerk at Prescriptions Inc., gave a detailed description of the two robbers and identified a photo of Steve as one of the robbers. Steve was represented in deposition by court-appointed counsel who made no effort to cross-examine Charles. Charles died before trial. At trial, the state attempted to introduce Charles' deposition testimony. Steve objected. What is true? Deposition testimony is admissible hearsay. The court should not admit the deposition testimony because it would violate Steve's constitutional right to confront the witness against him. The deposition testimony is admissible regardless of whether Charles was available to testify. Deposition testimony is admissible under an exception to the hearsay rule that applies only when the declarant is unavailable. Wait. Why'd you pick that? Sorry. I was answering a text message. The answer is definitely D here, because it's a statement against interest. So if you scroll down, I'll read why. The deposition testimony is admissible under the, I'm sorry, not statement against interest, former testimony exception. The deposition testimony is admissible under the former testimony exception to the hearsay rule that applies only when the declarant is unavailable. The former testimony exception allows for the admission of prior out-of-court statements made by a witness who is now unavailable to testify at trial. The exception applies when the prior testimony was given under oath in a deposition or other proceeding, and the party against whom the testimony is being offered had an opportunity to cross-examine the witness during that earlier proceeding. In this scenario, Charles, the witness who provided deposition testimony, is unavailable due to his death. Steve had an opportunity to cross-examine Charles during the deposition. Therefore, Charles' testimony may be admissible at trial under the former testimony exception to the hearsay rule. This guy literally texted me, I'm outside for your dogs. I'm going to leave soon. And I said, hey, give me 5 minutes. And then you guys got the question wrong. It took 3 seconds to freaking send a text. All right, let's continue. During an investigation, Reynolds gave an unsworn statement to a state's attorney investigator that implicated himself and Sorensen in a criminal scheme to defraud investors. Shortly after making the statement, Reynolds was killed. In a subsequent trial of Sorensen for criminal fraud, the prosecution called the investigator and asked her to recount what Reynolds said during the interview. The defense objected to the testimony on hearsay grounds. The testimony is admissible as admission, admissible as a statement against interest. Can you scroll down, please? Admissible because the statement was not made in furtherance of a conspiracy. Inadmissible because the investigator's testimony about Reynolds' out-of-court statement is hearsay within hearsay. Yes, I agree with you. It's going to be B. This is going to be a statement against interest. The last one was former testimony. This one's statement against interest. Admissible is a statement against interest. Statement against interest is an exception to the hearsay rule that allows for the admission of an out-of-court statement that are against the declarant's own interest at the time this statement was made. In this scenario, Reynolds' statements as state attorney's investigator implicate himself and Sorensen in a criminal scheme to defraud investors will be considered a statement against interest, even though Reynolds is now deceased. His statement can be admitted as evidence because its own interest intends to incriminate him. The prosecution can prevent the investigator's testimony recounting Reynolds' statement as evidence during Sorensen's trial. All right, now I think we're going to get into the brand new questions that they just released in 2023 for the new subjects. I told you these questions are insanely easy, which makes me feel like if they do test trust, secure transactions, or commercial paper, you're going to get similarly insanely easy questions. So everyone lock in, stay focused. My dog Sarah can wait just a few more minutes and we're going to finish strong. Simpson created an irrevocable trust with proceeds from the sale of an investment property. The trust instrument designated Thomas to serve as trustee and gave Thomas the duty to provide support payments to Simpson's children, Alice and Brian. The trust instrument further provided that upon Simpson's death, the remaining assets in the trust will be distributed equally to A, B, and Bright Future Center, a nonprofit organization dedicated to promoting youth sports. Simpson died 10 years later. 1 year before he died, Bright Future ceased operations because of lack of funding. A, B, and T cannot agree on how to distribute the trust remaining assets, which is correct. Because Bright Futures no longer exist, Alice and Brian must each receive a 1/2 share of the trust assets. Because Bright Futures no longer exists, that term of the trust fails and share of the trust assets pass to Simpson's heirs outside the trust. Because Bright Futures no longer exist, Alice and Brian can modify the terms of the trust to select another charity, regardless of whether Thomas agrees with them. Because Bright Futures no longer exist, the court may apply the doctrine of Cypress to modify the trust. Exactly. We're going to go with D. We're going to use the Cypress doctrine. Super simple, easy concept. Bright Futures, very near and dear to my heart. All my cousins are on Bright Futures. because they tutored with us for the SAT. Because Bright Future no longer exists, the court may apply the doctrine of Cypress to modify the trust. The doctrine of Cypress allows a court to modify the terms of a charitable trust when the original charitable purpose becomes impractical, impossible, or no longer possible to fulfill. In this scenario, Bright Futures, the designated charitable beneficiary, ceased operations before Simpson's death due to lack of funding. When a charitable organization named in trust no longer exists, the court can step in and apply the doctrine of Cypress to modify the trust terms. The court can determine a new charitable purpose or designate an alternative charitable organization that closely aligns with the original intent of the trust. The court's goal is to ensure that the trust assets are used in a manner that best fulfills the original charitable intent as closely as possible. In this case, since Bright Future no longer exists, the courts may intervene and modify the trust to select another charitable organization or charitable purpose that aligns with Simpson's original intent of promoting youth sports. The court's decision will aim to distribute the trust's remaining assets in a way that is consistent with Simpson's original intent, despite the cessation of Bright Futures. In a way, this entire presentation is brought to you by Bright Futures because Jacob, my man, got a Bright Future scholarship to Florida State. Now I got internship with Ibis Prep, and in due time, he put this together. Yeah, they are funded by the Florida Lottery, Omar, that's true. Benny is delinquent on a $15,000 credit card account with Credit Bank. Benny is also the beneficiary of an irrevocable trust established for support by his late mother. The trustee has a duty to make quarterly payments of $2,500 to Benny from the income generated from trust assets. The trust also includes a valid spendthrift provision. Spendthrift provision, we call it the Chet Hanks provision. I'm not defaming Chet Hanks because there is no malice. And it's probably true. Benny seeks your advice about whether Credit Bank can reach the payments that Benny receives from the trust if it obtains a judgment. What is correct? Credit Bank can force the trustee to make the quarterly payments directly to the Credit Bank until the debt is satisfied. Credit Bank can reach payments made from the trust only after the trustee has dispersed them to Benny. Credit Bank cannot reach the quarterly payments. Benny can voluntarily transfer his interest in the trust to Credit Bank to avoid litigation. Answer is definitely going to be B. The answer is B because the spendthrift provision will prevent outside creditors from piercing the corpus of the trust. We must remember who can pierce. Who can pierce? Alimony, child support, anyone who's worked on the trust, like says attorney, and then good old Uncle Sam. Credit Bank can reach the payments made from the trust only after the trustees distribute them to Benny. In this scenario, although the irrevocable trust contains a valid spendthrift provision, it does not completely protect the trust payments from being reached by Credit Bank. The spendthrift provision restricts the beneficiary's ability to transfer or assign their interest to the trust to creditors, but does not prevent creditors from reaching their trust payments once they distribute to the beneficiary. Credit Bank can potentially reach the payments made from the trust after the trustees distribute them to Benny. This means that if a trustee makes the quarterly payments to Benny, Credit Bank may be able to seek a court order to garnish or attach those payments to satisfy Benny's debt. So they can't pierce it, but they can garnish or attach once distributions are made. Let's continue. Sanders created an irrevocable trust for the support of her nephew, Nelson. Sanders appointed Turner as a trustee and contributed to the trust the publicly traded holdings or brokerage account, which had a value of $1 million. The payments that Nelson receives from the trust come from the income generated by trust assets or the proceeds of selling trust assets. Turner hired a financial advisor to assist with managing the trust assets. The value of the securities in the trust held steady for 3 years. Over that time, Turner monitored the securities performance and provided annual accounting to Nelson. In the 3 months since Turner has last provided accounting to Nelson, the value of the securities held by the trust dropped by 50%. Nelson has been asking Turner whether downturns in certain segments of the stock market have affected the trust, but Turner's not responded. Nelson seeks your advice about whether he can take any action against Turner, which is correct. Because the trust remains revocable, only Sanders may request the court to remove Turner as a trustee. Turner's hiring of a financial advisor was a breach of a trust because a trustee may not delegate one of her duties to a third party. The substantial diminution in value of the trust assets standing alone does not establish a breach of trust. Nelson does not have standing to bring an action for breach of trust or to request an accounting because he is not a qualified beneficiary. Definitely C, right? I told you, if you manage any stock portfolio over 2022, you probably lost money. That doesn't mean that you didn't prudently invest. You probably diversified and just lost money. The substantial diminution in value of trust assets standing alone does not establish a breach of trust. In this scenario, the substantial drop in the value of the securities held by the trust does not automatically establish a breach of trust on the part of Turner and the trustee. Trust assets are subject to market fluctuation. Investments can decrease in value. To determine whether Turner has breached their duties as a trustee, additional factors would need to be considered, such as whether the Turner failed to fulfill their fiduciary duties, acted negligently, or violated any specific terms outlined to the trust document. Davis asked lender for a $50,000 loan. Lender was willing to loan the $50,000 to Davis, provided that Davis uses her grandmother's antique furniture as collateral. Lender asks you for your legal advice in connection with the approach transaction. Which of the following is necessary for lender to obtain an enforceable security interest in the collateral? Boy, this sounds like an easy question. Davis must authenticate a security agreement that adequately describes the collateral. Okay, 2 + 2 is 4, yes. Davis must file a financing statement that adequately describes the collateral. Lender must take possession of the collateral. Lender must send Davis a writing confirming that the furniture will be used as collateral for the loan. Definitely A, right? That's how you are going to attach, be a security agreement. That's like 101 secured transactions. From my understanding, it doesn't seem like they're testing you on that devilish of details when it comes to new subjects. Davis must authenticate a security agreement that adequately describes the collateral. To obtain the enforceable security interest of the collateral, in this case, Davis' grandmother's antique furniture, lender must have a valid security agreement with Davis. Security agreement is a contract that establishes the terms and conditions of the secure transaction, including the collateral. For the security agreement to be enforceable, Davis must authenticate it, meaning she must sign or otherwise acknowledge the agreement. The security agreement must also adequately describe the collateral, which in this case is the grandmother's antique furniture. Adequate description typically includes specific details that reasonably identify the collateral, such as type, quantity, and any relevant identifying marks or characteristics. Moving along, nephew told aunt that she was considered dropping out of college after a difficult first semester. To convince him to stay in college, aunt promised to nephew that she would pay him $5,000 if he graduated from college within 4 years. Aunt signed a dated sheet of paper stating, "I promise to pay nephew $5,000 on the date from he graduated from college, so long as he graduates within 4 years." Is the sheet of paper a negotiable instrument under Article 3 of the UCC? Yes, because there's a written promise to pay a fixed amount of money. Yes, because it's functionally equivalent to a promissory note. No, because the promise to pay is conditional. No, because the promise to pay is not payable to bearer. Absolutely, it's conditional. Signed, written, unconditional, promise to pay a fixed sum of money with or without interest, on demand or definitive time, to order bearer with no additional undertakings. Why do I want you to memorize that? So you can spot any of these issues. It's conditional. A negotiable instrument must meet certain requirements, including being an unconditional promise or order to pay a fixed amount of money. In this case, the sheet of paper containing Ann's promise to pay nephew $5,000 upon his graduation from college within 4 years is conditional. The condition being that nephew must graduate within the specified time frame. And this is the final question, 69. And sorry, I don't want to waste a trip, although it's been almost half an hour, brother. I'm like, dude, this is the Florida bar exam. Come on, man. All right. Smith owns a store that sells musical instruments. Smith obtained a $40,000 loan from lender to fund renovations to the store. Smith and lender signed an agreement stating that the loan was secured by all of Smith's assets. Smith signed the agreement with a pen, while lender used an electronic image of lender's signature. Which is true? Smith authenticated the agreement under Article 9 UCC, but lender did not. Lender authenticated the agreement under Article 9 of the UCC, but Smith did not. The reference to all of Smith's assets in the security agreement did not accurately describe the collateral, and lender must perfect to obtain a security interest in the collateral. Definitely C, because we're not going to be able to use super generic or ultra generic terms. The reference to all of Smith's assets in the security agreement did not accurately describe the collateral. Under Article 9 of the UCC, a security agreement must contain a description of the collateral that reasonably identifies the collateral. While the reference to all of Smith's assets is broad, it does not provide a specific and identifiable description of the collateral. UCC requires a more precise description that enables a third party to identify the collateral that secures the loan. All right, let's click the next button. I think that should be all 69. 97%, not the worst we could have ever done. But what I want everyone to do on test day is literally this. You're going to go in there and you're going to smoke these essays. How do I know you're going to smoke these essays? Because, just give me 1 second. I'm going to do this. And then I'm gonna do this. All right, how do I know we're gonna smoke these essays? Because everyone's gonna come to my class on Saturday, and from 11 to 1, just as well as I just prepared everyone for the Florida multiple choice section, I'm going to prepare everyone for the Florida essays. So I'm telling you, when you go in there on test day, you smoke the essays, you go out, you have lunch, just like Joel said before class, it's a business trip. Headphones in, sunglasses on, don't talk to anyone. You go sit down, have some food, you pull up this 69 questions, and you 100% that thing. I want to see nothing but green lights. And if you do that right before the multiple choice section, I promise you're going to do amazing. If you have time, do all 433 of my questions too. But if you're in a time crunch and you can only do one thing before the multiple choice exam, it's those 69 questions, and you want to know them all cold. So I really, really appreciate everyone, including my dog sitter, my boxing trainer, and all of my students for gutting this out with me, because I think it was extremely valuable. And the number one thing I want to be in life is a man of value. So thank you all so much. I really hope you appreciated this. I appreciate you all so much, and I can't wait to see you all on Saturday and those I'll see tomorrow for the MBE class.